Through the concept of natural guardianship, a parent has all the decision-making authority over their child. By law, natural guardianship ends when a child turns 18. With respect to statutory guardianship, like when you become a guardian advocate, the court does not have jurisdiction over a child until they turn 18. That is, until they reach the age of majority, because there's no rights to remove from the child at that point because all the decision-making authority is still vested with the parent. If your child is still under 18, you have two options. Option one, you can file your guardian advocate application up to 6 months before your child's 18th birthday, and the guardianship decision-making process can be completed so your letters are issued effective as of your child's 18th birthday. Here's the rub. If you file before your child's 18th birthday, it will be your responsibility as the applicant to pay the filing fee, which is going to be $400, and for the mandatory court attorney for your child, which will be anywhere from between $1,000 and $3,000 or more, unless you meet the civil indigency criteria. And if you met this, you'd qualify for free legal services through legal aid, and you wouldn't need to take this course. So this is a serious expense. Now, there may be reasons why you want to make sure you have guardianship on your child's 18th birthday, and that desire may outweigh the additional expense. The second option you have is that you can file your application the day after your child's 18th birthday. So once your child turns 18, he or she is considered an adult in the eyes of the law, and the court's assessment about the ability to pay for the court's filing fee and the attorney for the ward will be based on your child's income and assets, not yours. Now, presumably, your child doesn't earn any money and doesn't have any meaningful financial assets, so more often than not, the children easily meet the civil indigent guidelines. You should note that when you're doing the analysis for civil indigent status, any payments your child receives from Social Security does not get counted as income for this analysis, nor does any personal property like clothing, furniture, tablets, laptops, that kind of stuff. Now, if you wait to file until after your child's 18th birthday, your application for civil indigency will be filed with the probate clerk at the same time that you file your guardian advocate application. If accepted, and nearly all of them are, the court will pay for all of these expenses, which is a huge savings of at least $1,500 or more. But there are some risks that you do need to know about. Once your child turns 18, they reach the age of majority, and your right to make decisions for them under natural guardianship ends. So technically, your child will ultimately be responsible for making decisions for themselves. Probably the most important thing to do to mitigate any risks is to make sure that your child's healthcare situation is under control and understanding what you would need to do in the event that your child required emergency medical treatment during the gap period. The only other real important area that you should be concerned about is your child's education, which can be managed by simply letting your child's IEP team know what your plans are with respect to obtaining guardianship and making sure that any important decisions that need to be made by the IEP team gets done before your child's 18th birthday. If you choose to wait until after your child's 18th birthday to file your guardian advocate application, I recommend that you have their application materials fully completed and ready to file on the first business day following your child's 18th birthday. You don't want to make that gap period any longer than it needs to be.